You went to school. You went to school. We are tired. Hey, let's move.
We assume that the deliberations will be inclusive and we are ready for the criminal case number 04/2024. Uganda.
Seven will die someday. Deep in my heart, I do believe. Seven will die someday.
We believe that yes, while the court has made a pronouncement, it may not be too late to accommodate that. Mitigation is part of the right of
his conduct. So that's what is going to be done. And since you have said you are not, we are not proceeding, we adjourn. Okay? After what?
Chairman and all court members, last time when this case was before this one, it was adjourned for adjournment. Not that it was adjourned for. It was adjourned for mention. And during the course of investigations, facts.
State, I don't know if they are saying they are not ready to continue.
Yeah. So we are ready.
Now then, when will you be working now?
I think, sir, we have already worked past the lunch time. I propose we can have adjournment for lunch and then the time to give the ruling against them, which is about Yes, no, we cannot go. We have the right to go for lunch, so you can have. Or you adjourn the main case, then the one of Chiza follows. It's okay, sir. No, that one, I think it will come up when they have known the fate of Jesus. That's, they clearly stated so.
We wanted to move with the amendment. We wanted to move court to have the charge sheet amended by addition of an accused person and also adding there another count.
Service and your colleague, your case is adjourned to 13th Jan 2025 for further mention. Time is 10 now.
Thank you, Mr. Chair. I request that housekeeping that on Monday when we come, security detail get
Those who are whistling and who are commanding others. On the 10th day of December 2024, the accused counsel appeared before this court representing Colonel retired Dr. Chiza Besigye and another in the above case, UPDF/GCM/040 of 2024. He expressed gross professional misconduct and he was warned that such a conduct is contempt of court. He was taken through the laws that make it an offense for the conduct he exhibited and warned. Today, the 7th day of January 2025, when the accused entered this court, he immediately confronted the court order that was guiding him where to sit, but instead started assaulting the court order and banging the angle bars of the entrance. The chairman of the court warned him of the misconduct, but he did not take heed, but instead worsened the situation by making more noise, being cheered by the audience. This court finds the accused's conduct in contempt of this court and finds Chiza Aaron guilty of the offense of contempt of court, and is hereby sentenced to 9 months in prison to be served in Chitaria government prison. We saw rule done at Makindi this day, 7th day of Jan 2025, under my hand and seal of this court.
We shall overcome someday. Deep in my heart, I do believe we shall overcome someday. Seven will die. Seven will die. A new law on.
Make some remarks, and of course, even the leader of opposition will address you on what has transpired today. We want to re-emphasize the point we have always highlighted. There is no justice in this building here. I don't want to call it a courtroom. Whatever is happening is a mockery of justice, travesty of the law, of the highest order. That's what is happening. The environment here, we have always talked about it. Everyone can attest to that. Transgression of the law, transgression of the highest order. What we have witnessed in the case of Chiza Aaron is nothing else but defilement or rape of the Constitution. Because at least, even if they were to subject him to whatever they have, the sentence they have handed down against him, probably there should have been a modicum of civility to have some semblance of trial of sorts. However shallow it could have been, or even if it was a sham trial, at least there should have been a semblance of a trial. But it's unprecedented in the history of this country, in our jurisprudence, that a person can just be sentenced without a formal charge. There is no charge sheet, without even some scintilla of evidence being adduced, at least to be granted a right to be heard, and also to be asked to take a plea and to explain yourself, in total violation of a non-derogable right enshrined in Article 28 and 44 of our Constitution, the right to a fair trial, a right to a fair hearing. Even criminals who have confessed, who have made, confessions, they are taken through certain processes. But right from the word go, they just bundled him, put him in the dock. Even when he was put in the dock, save for hugging Dr. Besigye and the Bedrutale, those are the only things he did in the dock. He was not permitted given any opportunity to say anything. Anything. He was just brutalized and all of a sudden sentenced to 9-month imprisonment at Chitalia. What a shame. They have rendered our Constitution a paper tiger, which is an absurdity. So we are not taking this matter lying down. As the legal fraternity, we are going to invite our colleagues at Uganda Law Society. We are in touch with our brother Semakadde. Good thing he campaigned on the platform of banging tables, and also Radical Bar. There are new dynamics introduced within the legal fraternity. This is a matter we have to address as a team. This is not a matter of Aaron Chiza alone. This is not a matter of the team that is representing Dr. Chiza Besigye here alone. This is not a matter for the political actors who are here alone. It's a matter for everybody who respects the due process, a matter for those who respect our constitutional order. So we are going to raise it with colleagues in the legal profession and see how it's going to be handled at that level by all lawyers, because it's an affront it's an affront, first of all, to the Constitution. It's an affront to the entire legal profession, and it's an affront to the right to practice our profession. And that is a matter we need to take seriously as a team. And this is what we are going to pursue vigorously. But regarding the matter of Dr. Chiza Besigye, again, it is really baffling. It's a matter which is really disturbing to us, that when we are still handling preliminary issues, then the judge advocate, not the judge, the prosecutor is jumping onto some other matters which are already choreographed. That they are coming up with a new count, they are adding some other person. These ones are quick to give a ruling, stampeding every known procedure in any given criminal justice system. It's being violated. So the whole environment here, as we have said, and we want to repeat the same, is not synonymous, is not, rather, the whole environment, the hostile environment here is not conducive for dispensation of justice. And this is a matter we want to pursue vigorously to ensure that justice is done.
You see, I have said severally that when you fight corruption, corruption fights back. It is also true that when you fight injustice, injustice fights back. That's what has happened to all the people that have been through this court martial. That's what has happened to Dr. Kiza Besigye or Bed Lutale, who are known fighters against injustice. Injustice is fighting back against them. That's what has happened to counsel Aaron Kiza, who is a known fighter against injustice in this country. It was very clear that they had planned to do this to Aaron Kiza because he's a known lawyer, part of the legal team, who was instructed by the accused persons. Court does not determine who should represent you in court. So Aaron Kiza is one of the lawyers. Why then do you bar him access to where the lawyers are seated? Why? It does not make sense at all. It's important that we stand up against this drama. We in the opposition, in the coming days, together with party leaders and so on, we are going to be touching base to establish what more we can get to do to push back. Because it's important that we push back. If they do these things and we keep quiet, it will become normalized. But you see, this should not just be a matter of we in the opposition. All right-thinking Ugandans should be bothered by these injustices because it's coming to you. You heard Mr. Museveni the other day saying bail should cease to be granted, police bond should cease to be granted. All of us must be concerned about these injustices. Today it is Dr. Kiza Besigye, Obed Lutale, Aaron Kiza. Tomorrow it will be you. When you're being denied bail, when you're being denied police bond, when you are probably before this tribunal here. So all right-thinking Ugandans should say no to this. We're hoping that in the coming days we'll hear religious leaders, cultural leaders, civil society, all right-thinking Ugandans speak out against this. It should not just be a question of we in the opposition because nobody is safe in a sinking boat.
Lawyer
Samuel Muyezi.
Samuel Mujesi to address you on that.
I don't want anyone to believe that this is today's event. Since we came to this court, our colleague was one of those who had been listed among those that were not really supposed to proceed in this matter. And the lead counsel then was well briefed about that matter. The list, which had 3 names of lawyers, by today had 10 names. Luckily, as I entered, I was allowed to enter into the bar. Aaron was following. And immediately Aaron tried to enter as one of the lead counsel in this matter. He was restrained by 2 officers. Of course, it was very clear. As you try to defend the rights of others, you expected to defend your rights too. The act of aggression was not by Aaron, but by the forces. The court orderlies. I don't even know if actually they're not court orderlies. By the military who have no name tags, which is also unlawful. The rest you also. Coming back to the issue of contempt, we received instructions while in the dock, and it was very clear. First, he gave instructions to all lawyers to represent him, and we were ready. He raised issues of torture. His arm was clearly dislocated. The marks were clear for anyone to see. I took a picture using my phone as part of the evidence. He had been strangled all through, up to the genitalia, as he put it. That everything that you can, he said was not even in his conscience to tell us on how to proceed because we wanted to share with him as a lawyer. He left it to us. But what he left to us, as you saw, were not even given a chance for him to be heard through his lawyers. And the rest is on record. Let no one tell this country that this was not premeditated. We have the list which had been made of those that somehow had to end up this way. It's not the first time. And this is so telling on why we say this is a kangaroo disciplinary, tribunal of the military. We have no space here. Even when we try to comply to what we should not comply. This is an act of aggression against all the lawyers in this matter. And we are not taking it lightly. From here, the lead counsel will tell you the next step. But we are not going to take it lightly. It's a twist in this matter, and a major one at that. I thank you.
In the court martial, before them, because the court was in session. When I found them taking him out and assaulting them, the court was in session, the chairman was seated. Everybody goes to court expecting that court or tribunal will protect you. So Aaron Chisa should have been protected. If you need to be removed, you are restrained and removed, not pounded with fists, with kicks, with all manner of assault. So I'm calling upon those of us who are able to record. We need to see exactly what happened, because when the court was giving the ruling on Aaron Chisa, they stated that he assaulted an orderly. But what my eyes saw were orderlies, not one. Orderlies assaulting Aaron Chisa. Even when he was at the dock, I saw him being assaulted. And I know he is injured. I didn't speak to him, but from those blows, he is injured. A court's first duty is to protect human rights. A court or a tribunal, and it is in the Constitution. Nothing about his well-being, just a sentence. We are very, very disturbed, and one wonders if an advocate coming to represent Chisa Besigye can be assaulted to that extent. Are they going to find justice in this military environment where use of force is what they know? It is very disturbing. Yeah.
Okay. Let's have the Luganda version. No, let's first get the lead of opposition. Let's first get the lead of opposition, then we give you the Luganda. Do you want Luganda from Martha Karua?
I will give them Kikuyu, it will be fine.
Okay.
With my freshly issued certificate to practice in Uganda for purposes of this case, but instead of the case against Dr. Besigye and Mr. Lutare proceeding, what has happened, we are leaving this court with one of the lawyers for Dr. Besigye, Aaron Chisa, having been assaulted and now sentenced by the court. I would like a colleague who saw what transpired initially, because we were at the back, entering when we found them, grabbing Aaron, assaulting him and getting him out of the court. I would like somebody who was present from the beginning.
You talked of that you revamped us with the required papers. And we talked about this the other time when we were here. Why didn't they fulfill that? Secondly, what you are talking about the assault, you are not talking about the conduct of your colleague. What type of conduct is that in the court? I think we also need to behave, because we are not here to show that we are in uniform. We are not here to support. We are here for justice, nothing else. But the way we are conducting ourselves, I think it may not help us. Instead, it will be affecting the accused persons.
May I respectfully urge you to also detail the orderlies, because every day we are being met by different people with different standards. The first day, 4 hours of standing outside there. I have not even
I think, sir, we are going astray.
And today, allow me to make my submission, for which I may not require your advice, the court will require it. I am saying that we are being subjected to different standards every day. The first day, 4 hours of standing, we have not even recovered from that fatigue. Today, over 2 hours. The second day, the 10th of December, we had an easier time. Today, I am informed, because I was at the back, I couldn't see. All Aaron Chiza wanted was to come in and sit, and he normally sits here. Even if there is no seat, an advocate should not be stopped from approaching the court. It is the court that would direct anybody without a seat go out. So there is something wrong with the way the preparation of the orderlies, and we would urge that there be strict instructions so that there is no back and forth. Before, the 2 times we have come before this tribunal, we have had no complaints about the way that the court, you said court, I will use the term. Sorry, yeah, it is not an offense. The way
Honorable Chairman, it is a contempt of court. I'm sure even senior counsel can be held in contempt.
But that's what I requested. Let us respect each other and we proceed.
Yes, I have already corrected myself, so I do not know what the judge advocate is complaining about. But what I'm saying is this, that Aaron Jesus should not have been stopped from coming in. I myself was stopped from coming in, and other lawyers on the 10th. We went to the back. We were then invited. But unlike me, Aaron Chiza is an advocate of the High Court of Uganda. He is known by the orderlies. So it looks like there was an intention to actually assault him. And we come here respectfully, we address the court, and we leave. And that's all that we need. How is it going to affect the 2 gentlemen on the dock when one of their lawyers is not there? May we respectfully ask for time to withdraw and confer with them so that we may now know what to do without one of us. Because each one of these lawyers has a specific task. The matter before you is the matter of life and death. That is why it has so many lawyers. We ask you respectfully to give us time with our clients.
Which time? Like
1 hour?
I think, sir, before you conclude on that, we have lawyers who never filed their practicing certificates. A current practicing certificate. Those who have not filed are not going to be part of this team until they file.
excuse me, but that one we are not reversing that. People who have fulfilled, we have given a senior counsel the chance to talk. Honorable Lukwago, you could sit first.
At least to be listened to. Mr. Chairman.
Honorable Lukwago, just take your seat and put the mic down.
But is this a word before you make a ruling?
You see this, senior counsel is talking of harassment outside, but what I have heard, partly it is caused by your people. That one I'm going to handle. I will talk to the security people. That one will be handled. But once we organize ourselves, because we want to know, yes, you are talking of lawyers, we are seeing them. But now, how can I know that this one is from this firm, this one has what? How can I know?
And this is the if you are not ready to follow the requirement, then you be there like any other person, or even you don't come here.
Mr. Chairman, I wanted to address you on that very issue. First of all, we already on record. The list was submitted. And indeed, you captured titulars of these advocates, their names, their law firms, and every aspect. That was
what did we agree on last time?
Yeah, that's exactly what I wanted to explain, Mr. Chairman.
Do you have papers?
Can I explain, Mr. Chairman? One thing, what happened, because the stringent rules he's reading, the judge advocate, would require that the accused person append their signature on the instruction. And we have attempted to access them in Ruzira to process that in vain. Today, if I may tell you, Mr. Chairman, you can ask and cross-check with the prisons authorities if it is possible for anyone to access Dr. Chiza Besigye and Obed Rutale. If you visited Ruzira Maximum Prison, the only way you can talk to them is through a landline, a phone. They are at a distance, so how are they going to sign on those instructions? If you insist on that, it will be a perversion of justice. You'll be perverting justice, Mr. Chairman, because it's not going to practically happen unless you are saying that we do it right now, that we prepare a paper, the list is here, we can present it to them, they sign, we file it. If that can do, if it can suffice, we are ready to comply with that. But if we are to access them in Ruzira, to sign instructions, that is not going to happen. The last thing, Mr. Chairman, he's insisting on PCs being filed with you. We are in a grace period of 3 months. 3 months. Right now, I have a right to practice without a renewed PC. Right now, until 1st March. So we are in January. We have all this grace period to process the practice certificate. I thought, as the advisor of this court, shouldn't even have raised this matter. It's totally very embarrassing that he's raising such a matter when he's supposed to be a senior advisor to this tribunal, General Court Martial.
Counsel Lukwago, if a grace period is there, you must come with the preceding certificate. It's what we want.
It expired.
We want that one.
You want an expired one?
Showing that you are practicing.
Expired PC?
Yes, the one which shows that you are practicing, but you are waiting to renew.
The only lawyer who has a 2025 PC now is Martha Karua. In Uganda.
We want the one.
The whole of Uganda.
Listen,
it's only Martha Karua right now.
Bring the one of.
Nobody else. So you saying no advocate should appear here?
The one of 2024.
That one is expired.
We want it. We want it.
Mr. Chairman. Mr. Chairman.
You see, I am mandated by law to say what I am saying. I don't think that you have practiced law more than me. So when I want a practicing certificate of the preceding year, it shows that you are waiting to renew. Why don't you want to bring it? Others have filed it. Why did they file and you have not filed it?
Please, if you are not among the three, I would like to hear from Mr. Karibara, if he's around.
He has somebody sitting in for him. Is that allowed? Yes, from his law firm. He's here.
Then another one is Katumba. Katumba. The three are not around. No, hold on before you speak. All the three are not around.
Mr. Chairman, I'm Frederick.
You are Frederick. Okay, counsel. It's okay.
And my colleague, Mr. Apollo Katumba, is here. Mr. Kalibala is not present. He's in this post. He's indisposed, that's why he's not here. But, yes. Mr. Chairman, I join issue with my senior colleague that because the year ends on the 31st, the process of inspecting chambers starts near to the end of the year and also continues up to in January and also February. And the law council can only issue practicing certificates after they have inspected chambers. So it is correct that we have a grace period up to the 1st of March. So apart from my colleague who has been given special dispensation, today my colleague Mr. Lukwago is correct that all of us, myself inclusive, don't have PCs for 2025. So we are just acting under the umbrella of the grace period. We urge and kindly ask the court to accommodate us, just like the other courts have done, because it is the practice. Otherwise, there would be no advocate going to court, Mr. Chairman.
So, counsel, are you ready to proceed with the proceedings?
My colleagues had raised the issue of getting an opportunity to talk to the client. It is correct that when we came in, there was a detailed security arrangement and a delay, and we're not able to speak to the clients. It's also correct, Mr. Chairman, that accessing the accused persons at Buzira prison is not easy. So unless there is an order from this court that their lawyers can access them freely, it might appear impractical. We ask for some dispensation so that, because, Mr. Chairman, the strict application of the rule the judge advocate is referring to is not quite practical in the current circumstances. And yet, for the accused persons, they're entitled to representation. So perhaps as the prosecution, the judge advocate, and the court, we can find a way around which is flexible, which will accommodate so that the accused persons are represented, because the most important thing is for the accused persons to have representation, Mr. Chairman. So we kindly ask, because it's within the powers of this court, to make that dispensation, but also to speak to them so that we don't come here and speak on our own before we have heard from them, Mr. Chairman. It's a polite request, Mr. Chairman.
Just a procedural matter, Mr. Chairman. In light of the guidance given by the judge advocate and the pronouncements made earlier on by the panel, we are at a loss as to the fate of the ruling which has been pending before this honorable court, because the matter was adjourned. The question that has been put to counsel is whether he's ready to proceed with the matter. And severally, this matter had been adjourned for purposes of delivering the ruling. And it's me who made the submissions. And from the list they are made, so, Mr. Chairman, would that ruling be still valid? Does it still stand that we wait for a ruling which is going to be based on submissions made by an advocate who presumably had no audience before this honorable court? So that is a serious procedural matter, so that if it is put out of the way, the anxiety and anticipation would have been addressed. It's okay.
Sir, the ruling can be delivered? Yes, because he says he wants to know, and I'm being misquoted that I am becoming strict with the rules. If you have been practicing in civil courts, they know you. But if you are coming here and you have never been here, we don't know that even last year you are practicing. And what I am advising court is that you must bring last year's certificate to know that you are in a grace period. Others have filed it. So, sir, there is no strict terms I'm bringing. That is my advice, and the ruling, it has always been ready. It can also be delivered so that Counsel Lukwago gets to know about the ruling, and we proceed from there.
Do you agree? Mr. Chairman, the polite request which is still on the floor is that we have a chance to speak to the clients. Otherwise, Mr. Chairman, is
Mr. Counsel, I don't know. Because what if it was read last time? What would have happened?
Mr. Chairman, the factual position as of now is that the ruling has not been delivered. So we kindly request, Mr. Chairman, that you permit us to speak with the accused persons. Hopefully, and perhaps before the ruling. We never know. We may have different instructions after we have spoken to them. We kindly request that you accommodate us, Mr. Chairman.
Does it have any harm?
No. They have always said they are not ready
Well, Mr. Chairman, the practice from the courts of law under the Constitution, like this one, which the Judge Advocate has advised us, is that a client can instruct you, and they are at liberty to instruct you before the court makes a final pronouncement on any matter. So to the extent that there was a request or an application by Mr. Erias Lukwago, my senior colleague, it is correct, I wasn't there. He was there and he made the submissions. The accused persons were there. And Mr. Chairman, I have not heard an objection from the accused persons and or Mr. Lukwago that they insist that the ruling is delivered before we speak to them. So to that extent, it is my polite prayer, Mr. Chairman, and I don't believe it would have anything prejudicial to this court that we speak to the accused persons before. It might change what we are going through, Mr. Chairman. It is a polite request.
And will be of use to the court. The absence of Aaron Chisa is a very fundamental issue, and until we talk to them, we do not know that what they're feeling about it is. So all these are matters that necessitate further instructions from them. I did indicate that each of the advocates appearing is covering a separate aspect. I do not know whether they are going to delegate the area Aaron Chisa was covering. I do not know their decision. So we are respectively again renewing our application that we be given time with the two gentlemen on the door and before the court resumes.
Much obliged, my Lord Chairman. Lord Chairman, this is the third time, and on the 6th, you had adjourned this court to make a ruling. And, Lord Chairman, that ruling has been pending. I therefore kindly pray that, as the land J guided, Lord Chairman, we receive the ruling, and that ruling will perhaps help us to sort out some of the issues that were raised by the lawyers for the accused persons. Therefore, Mr. Chairman, I pray that you be pleased to read the ruling. I so pray.
Final prayer, Mr. Chairman. Mr. Chairman, issues of instructions are fundamental. They are constitutional in nature. And indeed, you alluded to the fact that none of us here at the bar is at trial, and we are not the ones in the dock. The rights of the accused persons in the dock here are paramount. It's vital and important that before we commit ourselves to receiving the ruling, we have a word with them. Already, I'm being indicted of having made submissions on their behalf without instructions. And the court is going to proceed, or is invited to proceed and pronounce itself on a matter where there are serious allegations that the submissions were made by a stranger to the court, not an officer of court. Those are serious matters that must be addressed. Chairman, actually it touches on the conduct of the advocate, if that happens. So we do humbly request, Mr. Chairman, that before you proceed to make any pronouncement, we retreat, even if it's not an hour, even if it is 20 minutes, at least we have a word with, and more especially in light of today's happenings, the unfortunate incident that happened before you here, when one of us is not here, Counsel Aaron Chiza, the assault that has happened in this very room.
No, that one, Counsel, I have heard and I have seen.
Now we
The bad thing you are talking of what happened, you are not talking about the conduct of your colleague. I thought you are going to withdraw your submissions you submitted the other day if you are saying you are a stranger.
No, I said that is his opinion, that I had no audience at that time. Therefore, if I have no audience...
If you are withdrawing your submissions, then we can...
No, I'm not.
You can leave that at that.
I am not withdrawing the submissions.
Then if you are not withdrawing, let us read
I was making reference to his advice that I had no audience at the time I made the submissions. Mr. Chairman, that is the fundamental question.
I have not told you like that. We are waiting for the ruling of court.
Mr. Chairman, we do request that we be permitted this time to confer with the accused person. Just, even if it is 10 minutes, Mr. Chairman.
Counsel Lukwago, you are the one who submitted these submissions, and now we are giving you a ruling.
Mr. Chairman, we have no instruction to receive the ruling.
Take a seat and...
Mr. Chairman, we have no instruction to receive the ruling.
Counsel, who told you that to receive the ruling you need instructions?
No, everything that we do.
You are the one who submitted.
Everything that we do, Mr. Chairman, we need instructions.
You are the one who submitted before
Mr.
this
Chairman,
court.
we were instructed as a team.
Counsel, please.
And one of us,
take your seat and put
one
mic
of us,
down.
Honorable Chiza, has suffered the unfortunate incident which happened this morning. Mr. Chairman,
professional misconduct.
No,
reasonable force was used. Reasonable force was used.
Counsel Lukwago.
Mr. Chairman,
please, can you
Mr.
sit?
Chairman,
can you sit and listen?
Mr. Chairman, we wouldn't want to, because right now, even what you are doing, Mr. Chairman, if you are to go by his submission, the PC for the law firm of A.F. Mpanga that was submitted is one of Ernest Kalibara, and is not here. And you are insisting on that list given by the registrar.
But why do you talk for Kalibara? Talk for yourself.
Yes, because these are the matters invoked by.
Now, Counsel,
I request.
First tell me, are you withdrawing what you submitted the other day?
I need to confirm. I asked if I'm given instructions to withdraw, I will proceed. This is the instruction I'm seeking to receive. This is the instruction I'm seeking to receive from the client, whether we should withdraw or not. And that is the fundamental, Mr. Chairman. It is constitutional. Let us be guided by the Constitution. Mr. Chairman, it is this army which went to the bush and brought into place a new constitutional order. Let us respect it. Mr. Chairman, I request.
Now, who is not respecting the law?
I think sir read the ruling. Counsel Lukwago himself, you are the one who said that you don't know the effect of the ruling you will have on you in the case. So how do you make you turn now?
I've told you some of these things which are happening, which are not going right. Some are partly caused by you. So listen for the ruling.
Mr. Chairman.
Please. 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 Who is calling lawyers to stand up? Who is calling lawyers to stand up? Can you sit down? Go out. Go out if you want to go out. If you want to go out, please go out. We can listen even when you are seated. And we have been listening. Now who is who?
Mr. Chairman.
All of these people want to speak at the same time. You see them how they are standing. But we have one mic, which is in his hand. The mic is with Mr. Counsel Mpanga. The mic is with Counsel Mpanga.
I beg for your indulgence. The submissions of the matter coming, which is now before you, were made before we were on record. So we were not in court at that time. That is why our letter, cited by the member for the registry, is dated the 9th of December after the 6th when that hearing is. As submitted by my senior colleague, an hour might be long because we have lost 2 hours already. We kindly request for his handover. 15 minutes to so that I'm sorry. We kindly seek you.
The court is adjourned for 15 minutes.
Soko nyamba mfune kudowozi ya kaluwe. Kakuna yenze bintambi. Story nyingine wandika. Nze bifundeko. Hasa Kaulia's first sermon mission.
Isumi abadde.
Badde bawali kunga wali.
Nebako. Sabanango Juliet. Sabanango.
Nina kusaba kwa abana ba monitor ndafuna ko mugwensa.
Nanga wada. Uli mwana wa.
Kama nja saba noyo. Noyo abadde awandika bali kodi. Ada wandika. Ate zabukete byangu kwandika.
Bana ba ready balina.
Ya kubifuna si bizibu nnyo.
We submit it in, but for the record purposes, to read the names of the lawyers. The team is headed by Honorable Martha Karua, myself, Panga Frederick, Muizi Samuel Mulindwa, Aaron Chiza, who incidentally is in the hands of this martial court, Akakimpa Godfrey, Nalukola Ruhimbaz, Wanda Samuel Ronald, Kunihira Proskovia, Bayani Tulinawe, Kapshabe Ronald, Abdallah Chiwanuka, Sekanjako Abubakar, Chintu Mike, Katura Akram, Kakuru, oh, yes, Kakuru, Aaron, Isa Abirie Solomon, Kakuru Tumusime Kato, Nyanzi Idrisa, Kato Wilson, Odul Cyrus, Iduri Ronald, Captain, Major Iduri Ronald, Twahika Dennis, Faruku Kamlegea, Mukula George William, Jennifer Mathika, Apollo Katumba, Ngogerin, Ernest Kalibala, and others who are already on record, Mr. Chairman. That has also been ratified retrospectively by the accused persons. So they have appended their signature today, the 7th of January, 2025, and we would like to have it on record, Mr. Chairman. Unfortunately, we are left with no copy. We tried to get photocopying facilities with him here, or in vain. So, Mr. Chairman, I don't know how we shall, if court can review it, and then they get us copies, we would appreciate it. Yes? Mr. Chairman, we're operating under very difficult circumstances. We had no typing facilities around.
Please, Counsel Lukwago, also have respect to this court.
My colleague, this is a temporary paper we're giving the court. We undertake to have it typed, presented in form, and to have the individual advocates also submit the documents requested by the court.
At least say that, but not to present such a document to me.
We will.
We have had the demos. We just prepare properly, submit the list, and then we proceed.
May we also ask this court martial, Mr. Chairman, we issue directives to the prisons authorities to allow us access our client for purposes of having such a document signed, because earlier on I explained the intricacies involved in securing a document signed from Ruzira. What we go through is a nightmare, Mr. Chairman. Having said that, Mr. Chairman, the second limb of our submission, we have instructions, Mr. Chairman, not to proceed with the receiving the ruling until the fate of our colleague, who is part of the legal team, Aaron Chiza, is resolved, because we are not advised as to what is happening to him. We don't know the crime he has committed, if any, how he is being handled, and indeed the team is incomplete without one of us who has his own special duties
in regards to representation of the accused person. And under Article 28, Mr. Chairman, effective representation, rather fair hearing, has that critical element of legal representation which must be effective. So Aaron Chiza is one of the key members of this legal team, and he had to undergo what transpired this morning before you, Mr. Chairman, when he was subjected to that inhuman treatment. But our submission is that if he has any case to answer, if there is any issue this court martial has with him, we pray that it be resolved, one or the other, then we proceed with the matter. Those are the instructions we have, Mr. Chairman.
But let me ask the officer, the in charge prisoners who have come from Ruzira, where the accused people are, is it around? Oh, yes. SP, maybe you have heard what the council has submitted on. You can tell us if the accused people are not allowed to be visited or
My Lord Chairman and members of this Honorable Court, I want to make a few facts clear regarding visitation, particularly visits by lawyers. I want to categorically be clear that the lawyers who have come to see the two accused have always had and been given the opportunity to interact with these people. What we require from them is proper identification, my Lord. And that includes the ULSID, which shows their identity, and also an introduction letter from their law firms, that tells us about them and the purpose for which they have come to visit. And this is a standard rule for all visits by lawyers coming to visit any inmate at upper prison and at prisons at large. The lawyers who have put up that, who have raised that issue, I can also confirm to court that they have come to prison and they have been served. They have been accorded the necessary facilities to interact with their clients, and even some have gone on to have instructions of representation while at upper. So it is not true that that they are very stringent measures. Those are the measures, and they are as plain as that. I hope I have answered.
I think you have had yourselves. Now on the second issue, the court is going to deliberate about the conduct of Counsel Aaron Chiza. Although you are putting it maybe on the security people, you have seen what he has done, making a noise. The court have tried to stop him. He could not listen. Banging the angle bars, and it is not his first time to be warned about his conduct in this court. So the court is going to deliberate about